Okay, good morning everyone and welcome to our webinar on using dispute resolution boards to bring projects in on time and on budget. I'd like to introduce myself, Judy Mendoza, and our speaker, Elizabeth Tippin. So my name is Judy Mendoza. I'm in the Risk Management Department of Victor O'Shinera. I've been here about 20 years. And prior to being in the Risk Management Department, I worked at another insurance company where I was a regional claims manager handling claims against architects and engineers in 10 Western states. And it was during that role where I first came to know Elizabeth Tippin, who I would retain to defend architects and engineers who were insured in our program. And so we've known each other a very long time. Since then, Elizabeth has gone on to not only be an attorney representing architects and engineers, but she's also become an arbitrator, a mediator. She's a dispute resolution board member and an administrative law judge. She's been involved in resolving over 1,000 design and construction cases. She's a member of the Construction and Commercial Panel with the American Arbitration Association. She's a member of the Board of Directors for the Dispute Resolution Board Foundation, which we'll be talking about a little bit shortly. And she's a past member of the Board of Directors of the AIA San Francisco. She's currently a member of a training group for the International Federation of Consulting Engineers, or FIDIC, which for the use of DRBs on international construction projects. So as you can see, we've got quite an expert with us, and we're very happy to have her.
Well, thank you, Judy. That was a nice introduction. I really appreciate that. And when you know, we're giving a seminar on being on time and on budget, and we're starting late. So we'll try and speed things up so we can end on time.
Thank you. I appreciate that. Let me just go through a little bit of the housekeeping. The program's been approved for continuing education. So we will get back to you with whether you need certificates or that. Here are the learning objectives, and we're going to jump right into, the only thing I do want to say is, because the audience is muted, if you have any questions that you want to ask, you can type the question in the little question panel below on the side of your screen, and I will try to get to them during the course of it. So hopefully we'll be able to get to that. But let's jump right into talking about DRBs, and we're going to be explaining them very shortly, but since DRBs are used during the construction phase of the project, let's start by examining why the construction phase is so challenging.
Okay, well, it's hard enough when you have just two people to discuss things and resolve all conflict, but when you have a construction project, when there's multiple parties and multiple contracts and everybody has a different scope of work and a different licensing credentials and different compensation, and everybody's contract has different terms, it's challenging. And I think within every construction project, because they take a long time to resolve, they're so technical and issues pop up all the time, they are very unique and different than just manufacturing one product and then putting that on the market. Construction is very challenging technically and people-wise.
So, Elizabeth, what, in your opinion, do you think typically triggers disputes during the construction phase?
Negotiation constantly occurs on construction projects. Architects and engineers oftentimes have scopes of work that include going to the site and resolving issues as the project continues. There's a lot of technical issues, a lot of factual issues, but beyond the architects and engineers going to the site to discuss things, there are allegations that come up of errors and omissions. There's allegations of incomplete design packages, which lead to requests for information and change orders. But even before the contractor starts, they have bids that often vary widely. And a lot of projects, they're choosing the lowest responsible bidder, which means that that particular bidder may have made some errors in getting their price, and their process is to add change orders to increase or to make up the shortfall. Additionally, there's lack of coordination between the plans and just plain communication between the parties. All of that leads to a trigger for disputes to come up. And I will say it's important to kind of look at what is the definition of a dispute. Our requests for information, change orders, claims, all of those things do not automatically become a dispute, but they give rise to an issue. And the response to that is where the dispute actually arises. If the response is an outright rejection, if there's silence, or if there's a deadline and the deadline passes, then you could have a dispute that occurs on a project.
And
so some
maybe you could talk, go for it.
Examples of potential disputes, kind of in coordination with our slide here. All disputes are really differences of opinion. And it's not that one person is trying to pull the wool over other people's eyes, but there are different opinions that come up. And they result in claims that for delay damages or liquidated damages, change order claims, changes in schedule. There's construction defect claims that come up where the contractor doesn't comply with the contract documents, and all of that leads to litigation costs on the project.
I have to say, when I used to handle claims, handling claims for delays and extra costs were my least favorite type of claims. They were very complicated, very expensive, usually the longest ones to resolve, and just absolutely no fun at all. So I wanted to include this graph to just kind of give you an example of these are the claims that have been reported through the Shinera CNA program over a 10-year period from 2006 to 2015. And you can see that almost 50% of the claim payments were the result of claims for delays and extras. And frequency for those type of claims was over 40% of all the claims. So it's a big problem, and I think anything that can be done to reduce that would be very much appreciated. And then I also included this slide on the frequency and severity of who's making the claims against architects and engineers. And I think most of us understand by now that the majority of claims are made by the project owner. We're talking about 63% of all claims against design professionals come from the owner of the project. And in many of those cases, those are claims that originated with the contractor. Because while in some states and some jurisdictions, a contractor can make a claim directly against a design professional, even if they don't have a contract with the design professional. In most other jurisdictions, there's something called privity of contract. So a contractor can't bring a claim against the design firm if they didn't hire the design firm, but they would make their claim against the owner, who would then turn around and present the claim against the design firm, alleging that the design firm was responsible for the delays and extras. So you can see that's why the majority of claims are either damage incurred by the owner or they're pass-through claims from contractors. And I think it's also interesting when you add up all the claims that are made against design firms by the project owner and then the general contractor, the specialty contractors, bodily injury claims involving contractors, that's almost 78% of all the claims. So that from a risk management standpoint, that's good news because that's the parties that you need to direct your risk management activities to. If you can reduce those claims, that will help in the long run, I think.
Good points, Judy. Definitely pass-through claims is where if designers only had to design the project and it never had to be built, there probably wouldn't be hardly any claims. But it's the construction process that we really have the origin of claims.
Okay, so that kind of brings us then to how do DRBs bring claims in on time and on budget, and specifically how it relates to architects and engineers. So, let's start with, and actually we have a question that came in that I think is a good question, and here's an appropriate time to ask it. The question says, we keep referring to dispute resolution boards, and this person has heard the term dispute review boards. So he was wondering if they're the same or if there's any differences between them.
That's a really good question. I'm going to use the term dispute resolution boards, but there are dispute review board is the same term, dispute board, and a dispute adjudication board. These are all terms that could be utilized in specifications and contracts to define what is a DRB, the dispute, which is a panel of impartial professionals formed at the beginning of the project to follow the construction, encourage dispute avoidance, and assist in the resolution for the duration of the construction. And we're going to get into a little bit more about what that looks like, how they're formed, the history of DRBs, and understanding more about how they operate.
Okay, well, you mentioned it. Let's start with the history of DRBs. How long have they been around?
Before 1970, large construction disputes were resolved usually after an expenditure of an enormous sums of money for litigation and arbitration. And frankly, the parties were dissatisfied with the results. One party hated the result, the other party may have liked the results, or both parties hated the result. Early in the 1970s, the Underground Technology Research Council began exploring new approaches to dispute resolution. And one of the things, the first DRB, or Dispute Resolution Board, was actually used in 1975 in Colorado for the I-70 Eisenhower Tunnel project. Shortly thereafter, the Dispute Resolution Board Foundation was established, and they published a manual on how to do dispute resolution boards, and international members started accumulating. By the year 2010, there was over 2,000 U.S. projects worth $2 billion utilizing DRBs. And the whole focus was that how do we resolve conflict while the project is ongoing? That was the purpose of the studies of the Underground Technology Resource Council, and their studies were how can we be more proactive while the project is ongoing so that there's no construction or very little disputes and litigation, which was really spending more money than the cost of the project. So that was the whole history of how DRBs got started. Probably in 1981, the first international project occurred in Honduras. And shortly thereafter, the International Federation of Consulting Engineers decided to put in the DAB process as a requirement in all of their contract documents. They have 3 different main types of books: the Red Book, the Gold Book, and the MBA book, which is Design Build Book. Shortly thereafter, World Bank. So the banks were looking at how they could implement using dispute DABs. And the World Bank actually made dispute boards mandatory on all World Bank projects in excess of $50 million, followed shortly by other banks, the Asian Development Bank and the European Bank. So today, there's a lot of banks that require dispute boards that are funding international projects, the ICC, AAA. There's a number of other organizations that will provide dispute boards. So it's very integrated into the international and national markets at this time.
And then getting back to North American DRBs.
Yeah, the dispute resolution boards in North America, there's a lot of transportation organizations that are using them. United States Department of Transportation, Caltrans, Florida Department of Transportation, Nevada Department of Transportation are using DRBs on every single project. It's built into their specifications, and it's a mandatory requirement on every project that they be instituted. There's a lot of vertical construction projects that are using it. The University of California uses DRBs on all projects over a certain size. So a lot of highways, bridges, and also vertical construction projects are using DRBs.
Yeah, I think
and you can
this
see
one.
Go ahead. I was going to say you can see the statistics here that the Dispute Resolution Board has published that 98.7% of all projects are completed without subsequent dispute resolution methods, which would be arbitration or litigation. I mean, it's really an amazing process to resolve disputes real time while the project is ongoing.
I think that that 98.7% completed, to me, is an amazing statistic. And I think one of the most interesting experiences that I've learned about since we've been involved talking about DRBs involves the University of Washington. So maybe you could talk about that one a little bit.
Sure. The University of Washington decided that they would use DRBs in 1993. So they changed their construction contract and their specifications to include from using arbitration and litigation to mandating dispute resolution boards. They believed that too much money was being spent in the arbitration and litigation. So the early appointment of the DRB process resolved disputes, and you can see the results that are published here. After 23 years, 60 major projects, more than $6 billion spent on those projects, they had not been to arbitration or litigation since they had started using DRBs.
Well, okay, so now we're going to talk a little bit about how you actually create DRBs, and I think it'd be interesting to also talk about specifically how architects and engineers can influence the decision to include a DRB on a project.
Well, first of all, architects and engineers are really in a unique position to write the specifications for the project. They're in a unique position when the project is being designed and the specifications are created to talk to the owners about including a dispute resolution board requirement in the specifications. And what it does is it requires a stepped approach where all disputes, whatever they are required to go through this mandatory dispute resolution board process. The specifications require that all the parties, the owner, the contractor, and each of the DRB members sign a TPA, which is a third-party agreement or a three-party agreement. And there's usually operating procedures that are created that all parties agree to. So how it's created stems from the specifications, and then the agreement. There is the contract, the TPA, with the operating procedures, which is the rules and regulations of how the DRB is going to be operating. So in the European and I should say around the world, the FIDIC requires the International Federation of Consulting Engineers in their rules requires that each of the DRB members sign a separate agreement with the owner and the contractor. But they do adopt operating procedures that are one document, and the DRB functions together, the three people. There are some projects that I've heard about, international projects, a dam project in China where they actually selected 9 DRB members, and then for each if formal disputes, they actually selected 3 people who would actually hear the dispute. But all 9 people actually participated in the meetings of the DRB, which we're going to be talking about next. What do DRBs do?
Before we get to that, I was just thinking to ask if a design firm wanted assistance with the specifications to include in, with language to include in the specifications, where would they be able to get that?
They can actually go to the Dispute Resolution Board Foundation, drb.org, and they have developed sample specifications that can be used by design professionals, as well as the sample operating procedures. So everything's already been done and tried and tested in kind of best practices. So they offer that free of charge to anybody who wants to obtain that.
Great. And so what are the goals of a DRB when one is involved now in a project?
So basically, when the goals of the DRB is to resolve to communicate and resolve all disputes real time, which means that, what is the crystallization of a claim? What is the crystallization of a dispute? When there's a lot of negotiations as the project is ongoing, and the DRB, when the parties have decided that, it's risen to the level of something that they can't negotiate themselves, when it's risen to that level, then the DRB functions to resolve, to assist the parties in resolving the claim themselves.
And I kind of really want to emphasize the importance, I think, of trying to nip claims in the bud as early as you can. One thing I learned when I was handling claims, and we used to jokingly talk about how claims, unlike fine wine and cheese, do not get better over time. Claims seem to take on a life of their own, and the longer they evolve, they just start snowballing and getting larger and larger. So if there's a dispute and you can cut it off early before it starts down that road, I think that's to everybody's benefit.
Good point, Judy.
Okay, so let's talk about how do you become a DRB member, or how do you select a DRB to be on your project?
Okay, so first of all, the Dispute Resolution Board Foundation does provide training. They also, different organizations provide training, such as Caltrans. In order to be on their panel, you usually have to take the Dispute Resolution Board Foundation training, which is given around the country and really around the world at various times. Second of all, you need to be impartial. So you can't be an employee of one of the parties, such as the owner or the contractor. I think that you can't be a past employee of that if you, and you can't own stock. So how do you demonstrate that you're impartial? Additionally, experience in the construction industry. A lot of the disputes deal with highly technical issues, so you need to show that you have, the technical information of how that particular type of project is important. But not only experience in the technical issues, but also the contract interpretation, applying the contract to the facts. Basically, DRBs do not apply their personal feelings or a perception of fairness and equity. They actually comply with the contract terms and conditions. So the experience that we're looking for in DRB members is really a diversified experience. If it's 3 DRB members, then a technical person who's experienced in, say, that type of construction, if it's a curtain wall construction, high-rise building, and then contract interpretation. So we were looking for DRB members who are diversified and can bring together a experience range that's going to benefit understanding the project. And DRB members are sometimes attorneys, judges, arbitrators, contractors, design professionals, claim administrators. So they can be, any of those areas. I myself have been working in the construction and dispute resolution industry now since 1980, I guess it is. And so not only working as an arbitrator, mediator, but administrative law judge, and always focusing in the construction industry. Whereas another DRB member might have been working for a contractor or might be an engineer, and they have that technical ability. So when you're looking for DRB members, you're looking for a diversified group of people who can be informative and responsive to, the conditions on the particular types of projects that are being discussed.
How are DRB members selected?
The specifications actually set out a process of how the members are going to be selected, and the best practices form template that is available with DRBF sets out a practice where the owner selects one DRB member, or I should say nominates. The contractor nominates a number. They each have an opportunity to say, to reject that person. One opportunity to reject, and then the 2 people that are finally selected by the owner and the contractor actually select the 3rd person, who is usually the chair or sometimes they are just the third person, and then between the 3 DRB members, they select who will be the chair. All of them disclose conflicts of interest. So if they own stock or they've worked for a company, how many DRBs are they on? Availability is very important. After all of them are confirmed by the owner and the contractor, then they all sign the third-party agreement, which, as I said, in the United States is 1 agreement, whereas internationally there's 3 agreements.
And
so how does the DRB operate? Yeah, how they operate. So really, right after the members are selected, many times they're provided copies of the contract documents. So the plans and specifications, the bid documents, they're provided information so that they can become familiar with the project, the parties to the contract, and so they get that information. If they have questions or need something, all communications are through the chair. There's no ex-parte communications between the owner, the contractor, and the DRB members except through the chair. So the chair is kind of the focal point of communications between everybody. So beyond just getting all those contract documents, the DRB schedules regular meetings. The first meeting is scheduled at the project site. Usually there's a meeting in a conference room where sometimes the contract documents are distributed there, but they talk about the project. It's usually the very beginning of the project, but what's the schedule? Are there any problems that the contractor foresees at this time? Usually there's a resident engineer on the project, but the meetings, the owner's representative, the resident engineer, the contractor, they discuss at this first meeting how often they're going to have regular meetings at the project site, which is the beauty of the DRB, is usually there's a meeting at the site every month or quarterly, every 3 months. It's usually not less than quarterly. Parties can say, well, we don't have any disputes. We don't need you to be here. But the whole process of the DRB is to be on the site when things are just being discussed. And it's, all of the RFIs, the schedule, everything, things start creeping in to the discussions. And then they start formulating and crystallizing into a claim or a dispute. And the DRB is actually there before that happens.
We actually have a question that's right on point, so I'm going to ask that in a second. But first, I also want to give you credit, Elizabeth, for I know that this photograph that we're showing on this slide is one that you actually took during one of a site visit that you did on a project. So thank you for sharing that with us.
You're welcome. This is actually the Central Subway in San Francisco that's under construction right now, before the rails are put in. So this was just after the tunnel was completely, the bore was finished and the tunnel was completed.
Which kind of is interesting, because one of the questions that we received is, are DRB members required to sign an NDA to keep details of the contract and project confidential?
There is a confidentiality, and that is in the third-party agreement and also the specifications that the DRB members will keep the project confidential, keep all information about the project confidential. Okay, so the DRB, how does it really operate? There are the regular site visits, the meetings with all parties in a conference room, and then there's a site tour. The site tour is the owner and the resident engineer and the contractor, and everybody goes out to the site and walks the site to see, this is what we were talking about here, this is what we were talking about here. And it's through that process of everybody being together that there are, the things are discussed. And so there is a kind of a resolution of issues real time. However, if there is a dispute that rises to the level of being, a claim by the contractor, a rejection by the owner, either party can request to have an informal hearing. And an informal hearing is really where the parties make a presentation, the DRB sequesters itself and deliberates, and then the DRB comes back and gives an oral opinion about what the issue is. Usually there's the merits of the dispute, and then there's quantum, and usually they're separate. So they're not talking about how much something should, whether it's an extension of time or it's a changed condition, but they're talking about, yes, we view it as a changed condition, or no, we don't. And so they're really looking at the merits of the dispute and not looking at the quantum at that time. A formal hearing is actually where the parties make a presentation to the DRB, and the DRB leaves and they deliberate, and then there's a written opinion that's written that they all sign. So that written opinion is advisory, and when I say it's advisory, the parties can agree to accept it, or the parties can have further negotiations themselves. The model specifications from the Dispute Resolution Board Foundation say that the recommendation that the DRB provides can be used in later proceedings. So it could be used in arbitration or litigation, but the parties can use that. Now there are some contracts that change that provision, that provide that the opinion is advisory. So nobody's bound to go forward with what the DRB opines, but they don't want it admissible in a court or proceeding. And I have to say right here that my first introduction to DRBs was when I was hearing a case as an arbitrator, as an administrative law judge, and somebody submitted as a piece of evidence a DRB opinion. And I said, what is this? And so I got an education about what it was. Now, one of the parties was saying that we think it's incorrect because it doesn't follow the contract terms, but the fact is it is a very in-depth recommendation that's an inquiry by experts into the details of this construction dispute. So it goes through, this written opinion goes through what one party said, what the other party said, what the DRB observed, and what their opinion is about the contract documents, and how the parties should, what their opinion is. And again, it is advisory.
Okay, and now I know some, let's try to change this. Some firms may be concerned about what the costs are for DRB. So, how do the costs add up as part of the cost of the project?
Litigation and arbitration and delay on the project really cost millions, if not billions of dollars when you look at all the construction contracts across the United States and internationally. The direct costs of a DRB are a fraction of that. They're a fraction of what the total construction contract is. Typically, there is a daily fee for each member, and that's between $1,500 and, say, $3,000 a day. The daily fee is set out in a lot of times the specifications, as well as the third-party agreement. And then there's usually an hourly fee, which is for deliberating for those informal and formal hearings, or for board deliberations, or for review of the contract documents. So all in all, there's a lot less spent on a DRB than in the resulting arbitration and litigation.
Right. And I think these next few slides kind of summarize the benefits we've talked about of using DRBs.
Yeah, the DRBs really ensure fairness in the process. They don't have authority to ignore the contract. They must apply the contract terms. And the parties really are in the best position to resolve disputes real time while the project is ongoing. And the DRB is really a tool. They assist the parties in meeting and discussing issues in the conference room, in going out to the site and looking at things. And they encourage the avoidance of disputes, not the accumulation of unresolved issues. And as I said, they have extremely high resolution rates.
Yeah. This one again reiterates that the less than 2% of disputes referred to DRBs have gone on to arbitration or litigation, which I think is really an amazing statistic.
Yeah, it is amazing. They are such a huge cost savings. There's fewer end of project claims, if none at all. And as I said, litigation takes on a life of its own. Litigation and arbitration, lawyers, judges, experts, they're putting on a show, and they're in part looking at the facts. They're in part looking at photographs, because a lot of times they're not able to go out to the site to actually see they're not able to go out to the site to see the conditions when the issue occurred. So they're all looking at all the documentation, and all of that takes a long time and takes on a life of its own.
And I can confirm from our statistics that, again, the cost of the expenses that we pay on a claim typically far exceed the amount of any indemnity payment that's paid on a claim, because lawyers, experts, witnesses, all of that take a lot of money.
Right. So really one of the benefits of using DRBs is the contemporaneous resolution of disputes on the job level really ensures that there's a lot less hostile relationships between all the personnel, and hostile relationships are kept at a minimum. In fact, it builds trust. It promotes resolution, positive relationships, open communication, trust and cooperation, minimizes posturing. It really prevents disputes from rising. So it's a dispute avoidance process.
Okay. And I know we've talked a little bit about some of the type of projects that use DRBs, typically airports, bridges, buildings, dams, energy projects, highways, medical facilities, ports, power plants, underground, and universities. One of the questions that came in, which I think is probably appropriate right now to talk about, is how viable is this for small projects of, say, $1 million or less?
So I can just look at the University of California and Caltrans. If they have a project that is a small project, many times they will designate one person to be a dispute, well, not really a board, but a dispute advisor. So a lot of times there is somebody that is designated as one person in the specifications, and that person, as the owner and the contractor, need to designate at the beginning of the project to resolve disputes at the project level. Projects that reach a certain size, of course, then I said the 3 board. I told you about a project that was 9-member board. All of these projects, the lengthy duration, complex site, complex construction, high-risk projects, are probably more applicable for dispute resolution boards, but the concept can be utilized in smaller projects. And it also can be utilized in, the specifications could be written so that if architects and engineers have disputes that arise during a small project, they could also be wrapped into the whole process of resolving those disputes. And it's actually being used in other types of projects now. Any project where there is a lengthy process, i.e. manufacturing process. A lot of times, if there's a manufacturing process and they're using dispute boards to bring in to resolve disputes so that there's no litigation or arbitration at the end of that, a little more flowing and a little more developing in things that are outside of the construction industry, but certainly $1 million projects and less still have a lengthy duration of the construction process and could utilize DRBs.
Good point. And kind of another related question, which I think would be interesting to address, is the question is, mediation is also now frequently written into construction contracts for dispute resolution to be attempted before arbitration or litigation. Would you recommend mediation on a contract which is not large enough to justify a full DRB? I think you've kind of addressed that smaller projects can use a smaller, instead of 3-panel, they can have a 1 dispute resolution board member. And I don't know, it seems to me that although we certainly strongly recommend mediation as a dispute resolution system, by the time you're using mediation, the dispute has already grown. I think you'd agree with that. So, using a DRB perhaps may prevent it from even getting to that point.
Right, and I actually have a slide, just a couple ahead, that talks about the use of mediation. So when we get to that, we'll talk more about it. So,
which is kind of perfect lead into where we're going now, so go for it.
Right. Yeah, I would say DRB is a healer of conflict. You know, the open and frequent communication before the dispute really becomes a dispute, before the crystallization of that dispute, is the beauty of using a DRB, which is dispute avoidance. And, you know, that frequent communication, those meetings at the site, as well as the site visits to walk around the project, those are the key elements to resolving dispute. And DRBs really precede mediation or arbitration litigation. A lot of the international projects go from DRB to arbitration. They don't utilize mediation, but certainly mediation can be used by any party. This is the chart that I was talking about, which is looking at, you know, I'm going to say everybody can see the green, the yellow, and the red. The green is where you want to be. The yellow is, you know, in between, and the red is where you don't want to go. If you look at the very point of the red, that is a bench or a jury trial. And what happens in there is you have a high cost of resolution. If you see across the top, it says high cost resolution. And across the left-hand side, it says less control. So when you get to a bench or jury trial, you don't have a lot of control. You know, a judge or a jury of 12 people who are making a decision, and it's going to cost you a lot of money to get there. And, you know, you could have a jury of 12 people that could have a diversified background and have no technical information about construction. So it becomes very complex and is really doesn't work that well to go to a jury trial. So as you go up that ladder, and the most control, the most green, where you have the most control and the least cost, is negotiation. So dispute resolution boards really start at the beginning of the project to facilitate negotiation between the actual parties. The other things that are in that: partnering, facilitation, help, and usually, you know, help to establish a good relationship between the parties. The yellow zone is where mediation comes in. So you really have a lot of control in mediation because they're not going to force you to settle. The mediator has no power to make you settle at a certain rate, certain amount of money. But you're starting to feel like, oh, I'm spending a lot of money getting to that point. You usually have an attorney. You usually have experts. You usually have spent a lot of money at that point. So it's getting close to the red zone. And certainly arbitration, you know, in that red zone, not as risky as a jury trial, but arbitration, you get to select who your arbitrator or arbitrators is. But again, you have no control. So in the red zone, no control. The yellow zone, you have control over the outcome because no one can force you to do anything, but it's still, you've spent a lot of money. So stay in the green zone.
Yeah. And again, our statistics really back this up. I'd say only about 5% of our claims go all the way to what we call an adjudicated verdict, where some third party, such as an arbitrator or a judge or a jury, is deciding your fate. Because it is a crapshoot. You don't really know if they're going to understand the issues, and it is very, very expensive. And sometimes they just want to spread the wealth among the parties who are involved, you know, even if there's not clear liability or any liability against a party. So, yeah, we always really encourage the green and the yellow zones are where you want to be.
Right. Good.
Okay. Well, so you mentioned earlier, we talked a little bit about the Dispute Resolution Board Foundation.
So
more information on it.
Yeah, the website is right at the bottom there, and the DRBF holds classes all the time for owners, architects, contractors, DRB members, arbitrators, mediators, judges, can take any of the classes. The Practices and Procedures Manual, the specifications, the operating manual are available on the website. And I did want to just note that if you go to the website, you can learn about the conferences that are available in the United States and Europe. There's an international conference in May that's in Madrid, Spain. And the next national conference in the United States is in September. It's the annual national conference. At those conferences, they are multi-day conferences. There are training sessions. There are people speaking on how they're using DRBs and how they have been used for various projects, PP3 projects, design build projects. You can get a lot of information from actually going to these conferences. And there's numerous articles that are available also on the website. So I encourage everybody to explore it and see what meets your needs.
All right, which brings us to the 10 tips for successful DRB.
And I know we only have about 5 minutes left, so we're going to go through these really quickly. But first off, the DRB members should be neutral, so impartial, and approval of all parties. So you're choosing people that are selected for by all parties, and everybody starts out on the right foot. So everybody signs a third-party agreement. As I mentioned, the third-party agreement, there are some samples on the DRBF website. And in the United States, there's one agreement with everybody signs. In all of the rest of the world, there's usually each DRB member signs an agreement with the owner and the contractor. I should say that there's also ethical issues, that there's ethics standards and codes that are on the DRBF website, and a lot of times those are just impacted or imprinted into the third-party agreements. So that's important. So DRB fees and expenses, usually the contractor, and this is pretty much across the world, the contractor, all invoices from the DRB members are sent to the contractor, they pay it, and then they get reimbursed 50% by the owner. So they're really owner-contractor paid and shared equally between the parties. So number 4.
I just wanted to reiterate on the sharing equally. I think that's always important. I mean, like with mediations and the parties all share equally, I think it makes sure that each party is equally vested in the process. Yeah. So I think that's a lot of why they do that.
It's really important. Number 4, it's really important to have the DRB organized when work begins, before there's any disputes, because the beauty of using a DRB is dispute avoidance. You don't want to wait until there is a dispute and then say, oh, well, we don't need it at the beginning, let's get one now. And then the parties are disagreeing, and it's harder to develop who are the people that are going to be on the DRB. Number 5, the DRB keeps abreast of job developments, periodically reviewing all the documentation and visiting the site. This is so important, and there are, a history of DRBs that didn't do this, and it didn't work. It didn't avoid disputes. They didn't want the DRB to start until there was a dispute, and then it was more difficult for the DRB to get information. They didn't know the parties, they didn't know the contract documents, they haven't been out at the site. So the whole thing works when it functions like it's designed by the Dispute Resolution Board Foundation. Number 6 is the parties have available to them an advisory opinion process. So what this does is it provides a tool for the parties they're going to resolve a lot of issues just by negotiation and talking about them. I need an RFI, here's a change order. If the parties can resolve that themselves, as most do. But what this does is it has available to them an independent 3-party board that's going to give them an advisory opinion on how they should resolve it. And that advisory opinion really goes to resolve most all of the complaints. Number 7, either party can refer a dispute to DRB. So it could be an owner saying, here's a dispute, or the contractor saying there's a dispute. There's been a crystallization of the dispute, and either party can review it. Number 8.
Can I just ask, could a design professional refer a dispute or suggest to an owner or contractor?
The design professional on the projects that I've been involved with are definitely working with the owner more, and they certainly can recommend to the owner. It's usually the project engineer who could refer a dispute, but the owner can refer it. You know, any of the parties who are involved in it can bring the dispute forward to the DRB. Number 8, an informal but comprehensive hearing is convened promptly. You know, the whole key to that is the promptly part. Because the DRB is meeting at the site monthly or quarterly at the most, you know, a lot of potential disputes are discussed in those meetings. But beyond that, either party can request a DRB informal or formal hearing immediately. So within 30 days, there's usually a scheduled time period. DRB members have flexible schedules. They're available at, you know, notice from the parties. So number 9, written recommendations of the DRB are not binding, but are admissible later in arbitration or litigation. So we talked about this earlier, that they're advisory. And I actually was in an arbitration where it became a piece of evidence, and it is a piece of evidence. Number 10, DR members are absolved from personal or professional liability arising from the DRB activities. And this is in the third-party agreement and also in the specifications, so the model specifications. So they're not called as a witness to, and if there is a subsequent proceeding, an arbitration or litigation, they're not called as a witness. They're there. The piece of evidence that they wrote can be, or the advisory opinion can be introduced as evidence, but they're not there to actually be a witness to what happened. So that's the 10 tips.
All right, which kind of brings us to questions, but whoops. It looks like we've already responded. I think we've answered all the questions that have come in so far. So the only other thing that I want to do just to wrap it up is to remind you that Andrea Tyler, and here's her email address, is available should anybody have any follow-up questions, especially in terms of getting certificates of attendance or continuing education with the AIA. I recognize that some of you, might have more than one or two people, may have a group of people with one login. So if you need additional certificates for the people who are attending, we can take care of that for you. And just remind you that our next webinar is coming up on April 12th. And I just want to very much thank Elizabeth for her time and for sharing your expertise with us. I think this was really enlightening.
Great. Well, thank you, Judy, for inviting me. Appreciate it.